Hey, graduates, wagwan, wagwan. Boy, I never thought I'd be back this quick, but I needed to drop this information. Big up yourself to the person in my comments who alerted me to this release of court documents around CMR. Yes, we're going at it. Let us read it together. So remember, I was waiting for these documents to drop. I needed to see what the two-page correspondence was that CMR had written to the judge. Well, it has arrived. In addition to that, we also have the court minutes. We're going to go through it bit by bit so you know exactly what went and what took place. Because, say, I have to laugh to myself, graduates. A few people were telling me how, some bloggers were claiming that HTK tell lie, not no go so. Police couldn't tell her all of these things. Well, I'm about to show you that the documents reflected exactly what the police had on file. Anyway, let's go into it. First, we're going to talk about the two-page correspondence document that was sent from CMR to the judge. So as you can see, he addressed the letter to the Honorable Judge Michael Snore, who is the person who was overseeing the whole case. According to this, it says, I am writing to respectfully request that the court consider placing additional privacy restrictions on, and it gives the case number, due to serious concerns for the privacy and well-being of our family, particularly our minor child involved in this case as a family with a public profile. We are widely recognized across various social media platforms. This case, which involves our minor daughter, has attracted significant attention with personal details circulating publicly. Despite redactions in the files, the public were able, meaning various social media platforms and blog sites, was still to discern her identity due to our family's visibility and specific details in the case. This exposure has subjected her to targeted harassment, affecting her mental health and leading to distress within the family. Additionally, this information in the public, our daughter is considerably distracted and anxious as she faces not only public judgment, but also the trauma of seeing sensitive details of her life being scrutinized and misinterpreted. We kindly ask for an order restricting the public access to my information about this case, including details involving detectives and any statements made by our minor daughter. We hope to safeguard her privacy and mitigate further harm to her and our family. This case's public status has taken an emotional toll on all of us, particularly on our daughters, and the one whose involvement as a minor should be protected. Thank you, and signed by Dotty Man CMR. Look here. Some have a laugh because what a man lie, right? Big up yourself, courts of Orange County, Florida, because you saw it fit to reveal this to the public for a very good reason. You realize that this man was using further manipulation to silence public documents that would reveal his manipulative ways, his lying ways. And you saw it fit to ignore this because otherwise these documents would not be privy to public scrutiny. So we all know that the course of justice is taking place, and they believe that this information needs to be out there. Now, we're going to address it bit by bit because, according to this letter, he is claiming that Jay has received targeted harassment. Now, I'm wondering if the targeted harassment is coming from the blogging sites, the bloggers, the social media sites, or is it coming directly from the children that are in her peer group? Because there is no way I could ever see any blogger reaching out directly to Jay to harass her in any way. Yes, the information has become public. I do not even know which blogger it was that released it all, but there was one blogger who had put up the documents and everything. Now, we have since picked up the case and have been exploring it and recognizing that it has been inappropriately handled and managed by the Carter family. You cannot stop that from happening once you are a public figure. Come on, who could stop the CDD case from going public? Who could stop people from discussing it? Nobody. When you are a public figure on a certain level and things like this reach you, there is no protection that the law is going to give you as priority. And you ain't even that big, mate. Anyway, let's continue. Now, what is ridiculous is that this man is trying to use Jay in order to cover his tracks. Because here it is that he is talking specifically about the daughter being distracted and anxious and that she is facing public judgment. Now, you went on the fix and you gave the impression to the world that the little girl lied and that the detective had not done their job. So it's okay for you to imply that your daughter is not being truthful. And it's okay for you to say that the processes of law has not taken place sufficiently. But, which is all a lie. But here it is, you're claiming that this little girl is facing judgment. When you implied that she lied, did she not face public judgment, CMR? Now, you are also talking about sensitive details of our life being scrutinized and misinterpreted. We are scrutinized. And any misinterpretation is because of how you people have handled this case. But once again, here is an example of you not taking accountability about the role that you played in how this information has been handled on social media and on the internet. So this man, clearly unaware of the laws of the land, is requesting that public access is restricted to his information about the case and also the details involving the detectives and any statement made by the minor daughter. So he wants the statement to be hidden. He wants the arrest record to be covered. It's like him thinks that him is some kind of god or some kind of diplomat. You are not entitled to this level of secrecy, especially when you have already asked for the sealing of a case when it came to your DV case back in 2021. You're only allowed to do it once, not twice. And something like this is not something that you can cover up and hide, which is what you would love to do. It's interesting that you're claiming that you're wanting to safeguard her privacy and mitigate further harm to her and the family. What is interesting is that you said further harm because, sir, the original harm was already happening from she went and made that report against you. Those allegations were the real harm that started all of this spiraling of information out of control in the public arena. Nobody is to be blamed but you. Why is it that your child is pointing a finger at the man who raised her from she was a baby? You still cannot come to the public and explain what has taken place. Instead, you have come to the public with several lies in order to cover your tracks and continue to do so. Even the court recognizes within this document that that is exactly what you were trying to do, to hide your shame. Don't try and use Jay as a reason to cover up what it is that you have allegations about, what it is that you were arrested and charged for. Don't try and do that. Because you're trying to give the court of the land the impression that we are out here trying to target your daughter. Sir, it is you who tried to target your daughter according to the records that are public access, not us. So when you come with this kind of thing here, you think the courts can't see through you? Clearly they could, and that's why they have been released for public scrutiny. So let us now look at the court minutes that have also been released. As you can see here, this is what you call an order of commitment. Now, in this order of commitment, you are going to hear exactly why it is that CMR was not allowed to be in the house. And we still have question marks about whether or not CMR actually still lives in that premise. Listen. So according to this, there is on one count of lewd, lascivious behavior when it comes to SM a child that is less than 16. According to this, he was arrested on a probable cause determination made that the defendant committed the crimes charged in the complaint. So a probable cause determination is hereby made that the defendant committed the crimes charged in the complaint. All right. This document is coming from the sheriff of Orange County upon the charges made in the complaint. It goes on to talk about the pretrial detention and the notice of hearing and the special conditions of any release or plea. These are the conditions that the police also repeated to HTK. No contact directly or indirectly with the victim. Do not return to the scene of offense. He may return one time with law enforcement to get personal belongings, and we saw that at the court. That was said. Maintain separate residence. It didn't say temporarily, it says maintain separate residence. This was then signed off by the deputy court, and the order was made on the 3rd of November 2024. So under these conditions is what was expected of CMR leading up to CPS involvement. So the police, as far as they were concerned, this is what he had to operate on even after any release or plea. So this is not just while on bail. This is after release or plea. So let me say something. Many are questioning why it is that he's back in the house, etc., etc. CPS would have taken control at some point when it comes to assessing and safeguarding that child and the living circumstance. And with a parent who was not willing to push for justice like the child's mother, there was no choice but to release things after the 60 days because he was compliant with all of the terms and conditions of CPS. Remember, they were busy going to church praising the Lord, talking about God is love. How much less of this are you now hearing? Of course, some of you sheep are not gonna admit it. But CMR, we see you for exactly who you are. And the public will see you too. This is your girl, Head Teacher K, and I'm out.